REN TV coverage of the 2013 IRMI Energy Risk and Insurance Conference is sponsored by WebCE. Tracy Saxe is a partner at the law firm of Saxe Doerenberger Vita. He was part of a panel discussion at the IRMI Energy Conference talking about business interruption coverages available to energy companies.
Well, the first-party commercial risk is magnified, first of all, in the energy sector, because the losses tend to be tremendous when it comes to the business interruption piece, and that's the real focus. A well-educated team putting these matters together, these proofs of loss together, ends up putting together a much more valuable claim and a much more timely claim, and the recovery is faster, is less likely to result in litigation, and ends up maximizing your results for the entire team. Certainly Katrina was a good example of a major impact on the energy industry that would be covered under a commercial property all-risk policy and the time element or business interruption coverage that would flow from that. But there's also the interesting issues that you have an expected large hurricane coming through and you prepare for it. Maybe you shut down your refinery, maybe you shut down your nuclear reactor, maybe you shut down something, and it can take considerable amount of time and energy, excuse the pun, to put that back into the works and get it going again, and that interruption loss may still be covered as preservation of property, potentially, depending on the policy language. But certainly all of the preparations and the costs associated with preparing for the storm, even if the storm didn't occur, will be typically covered under what's called sue and labor. When you have a long-term relationship with a particular carrier, you've been good about giving them good estimates of your business interruption values in advance when the premiums were taken. Even though you may not lose coverage for having given not as accurate business interruption values, you're going to probably find there's a lot more resistance when the insurance company suddenly has a business interruption loss which is way beyond what they modeled for this particular client. Sometimes the claim is not well prepared. Sometimes the relationship has been impaired for other reasons because of bad communication. Maybe there hasn't been exceptional cooperation on all the reasonable requests for information from an insurance company in preparing the claim. That's not to say that sometimes there aren't unreasonable requests for information. That's not to say that sometimes in a large claim the insurance company is not being as forthcoming as they might be on making interim payments on undisputed parts of the claim, which they should do. Sometimes we've been forced into going to appraisal on quantification. Sometimes we've been forced into arbitration or declaratory judgment actions on coverage disputes on different issues. There's no doubt about what happened, but the characterization of it might fall within a sublimit if you characterize it one way. It might fall within exclusion if you characterize it another way. And it might be just fully covered without any limitation whatsoever if it's characterized a different way. And knowing what the policy says and what you should be doing to characterize the claim properly is important before you make the first statement about the claim. If you understand what your coverage says, you're likely to use the proper vocabulary so as not to trip yourself into an exclusion or a sublimit, which otherwise probably wouldn't apply if you had used the wrong words.
For more world risk and insurance news from the IRMI Energy Risk and Insurance Conference, visit the REN TV On Demand Library.